New tonight, we're tracking a new Assembly bill that's raising concerns and causing confusion about how it could impact your right to defend yourself. Assembly Bill 1333, which aims to tighten rules around self-defense. But the lawmaker who introduced the bill insists the intent is misunderstood and promises changes.
Is the language really misunderstood? Did Democrats in the state of California really need to pass another law updating their long-standing self-defense statute, their long-standing castle doctrine, which, by the way, exists in some form or another in 50 states in the union, where it protects your right from having a duty to retreat in your own home where somebody breaks into said home? Absolutely not. No way. Not even close. Greetings and salutations, everyone. My name is Sean, and today we got to talk about yet another example of Democrats not learning a lesson and deciding to advocate for the criminal over the law-abiding citizen. And in this particular case, they have decided to essentially erode, nearly erasing the castle doctrine in the state of California if this bill ends up becoming law. Now, we're going to talk about this. We're going to break this down. But before we do, I want to thank everybody who supports this channel via actualjusticewarrior.com/join.
Give me the money. Give me the money. Okay.
Also, thank you for the shout out, Mr. Matt Walsh.
Here she is on her show a little while ago, articulating her case for allowing men to compete against women. And I couldn't find the original video on Emma's channel, so I'm pulling this from this clip from a video on the channel Actual Justice Warrior, which you should check out to hear his take on this as well.
But you should definitely consider following me on Twitter. I don't know exactly why, but I can never get any Daily Wire people to follow me on Twitter. Is it something wrong with my face? What is it? Do I smell bad? Can you smell me through the screen? Whatever. We're not going to focus on this too much, but still, I'm a little bit offended.
Laura, the bill, I am told, seeks to close a loophole following a 2022 Supreme Court decision that expands gun rights. But the original language in the bill surrounding self-defense has left opponents worried. So I spoke to the bill's author and opponent, also an opponent and a defense attorney, to get their take on what's at stake.
So due to the controversy that is surrounding this particular bill, obviously it has gone viral on social media, this local news reporter for this ABC affiliate has decided to talk to the lawmaker that is behind this in order to get his explanation for why these changes were totally necessary, even though they absolutely weren't, and whether or not this would actually erode self-defense protections. And guess what? They absolutely will. So we're going to hear what this representative actually has to say about this, but then we're actually going to go to the text of the bill, and I'm going to show you exactly what was removed and exactly what language was used to replace what was removed, because it makes it unambiguously clear where this person is coming from, despite what he says.
Assembly Bill 1333, released 2 weeks ago, was meant to address what some see as a growing problem with vigilantism and public gun use, after a Supreme Court ruling nearly 3 years ago expanded the right to carry handguns in public for self-defense.
That is intended to make sure that people understand that they can't go out in public, pick a fight with someone, and then shoot them and rely on self-defense as a defense in those cases.
So let's make something 100% clear for everybody out there in the audience. That explanation from this state representative is objectively nonsense. According to him, California has a loophole in their self-defense statute that was created by the Bruin decision that somehow made it legal in the state of California for people to pick fights, take out a gun in the middle of the fight that they started, and then shoot and kill the person in a fight that they then initiated. And I just want to point out, in case you're wondering if this is the case, it is absolutely not the case. In no way, shape, or form has it ever been the case. And in fact, even in states with the strongest stand your ground type of protections, do not have a provision that allows you to do so. Typically, if you start an altercation, you cannot use deadly force as a mechanism in order to defend yourself, unless, of course, you have withdrawn from the altercation that you've started, or if you started a fist fight, that other person pulled out a deadly weapon in order to combat your regular force, and they escalated it to a deadly force situation. It is not at all covered in any way for you to initiate a fight, somebody throws a punch back at you, and then you pull out a gun and blow them away, and definitely not in the state of California.
But the bill's original language has sparked confusion and backlash. One part of the proposal says killing someone in certain situations, such as to protect your home or belongings, is no longer considered justifiable. Neither is when excessive force is used.
This bill does nothing and will do nothing to prevent someone from protecting themselves, their loved ones, or their home.
One of the reasons why we're going to pull up the actual bill's text for you guys out there in the audience is because if you examine the document that the local news has put up for us closely, what you find out is that this is the legislative digest. It doesn't actually have the new law law in comparison to the previous law where you could see the changes that were made, because if they did show you that, as it is featured on the California Assembly website, what you would find out is that it 100% undeniably restricts your rights in order to defend yourself, in order to defend your home, and essentially repeals the castle doctrine. Don't believe me? Well, guess what? We have the text right here, and conveniently, the old text has been crossed out in red and has been replaced with new text. So this is section 197 of California's Penal Code, and it reads as follows. So the original text says that a homicide is also justifiable when committed by any person in any, which is crossed out and replaced with all of the following cases. Number one used to read when resisting any attempt to murder any person or commit a felony. Now it just says when resisting any attempt to murder or to do something to cause great bodily injury upon any person. So right away, there's already a giant red flag, because you can see right there, they took out the language about the felony that you could also resist with deadly force if it were to be committed upon you. And you might say, oh, well, that's no big deal. Not all felonies should be classified this way. But here's the thing. Do you really want it to be up to California prosecutors when somebody pulls out a gun and he attempts to carjack you on whether or not you can be prosecuted if you were to defend yourself in that deadly force situation? Now, they'll argue in the prosecution of this particular case, which they would not be able to do before, that that person only intended to take your vehicle and you were not really at risk of serious bodily injury, or you could at least make a case that you weren't. Maybe he had a knife, maybe he had a bat or whatever, so you can't resist in a way that would potentially kill that person. What about a rape? Technically, a rape is one of the most serious felonies, but is it always 100% a risk to serious bodily damage, again, that would cause permanent long-term injuries of a physical nature? Absolutely not. There are many such instances where that's not the case, and guess what? If you're a woman and use a firearm to protect yourself in this particular incident, a rape may be included. They may not go after you, but go down the scale to different sexual assaults and you'll start to realize why this creates a bunch of different various problems. And again, we're not even at the castle doctrine portion. Next, we have 197 section 2, which used to read, when committed in defense of a habitation, property, or person against one who manifestly intends or endeavors by violence or surprise to commit a felony, or against one who manifestly intends and endeavor in a violent, riotous, tumultuous manner to enter the habitation of another person for the purpose of offering violence to any person therein. Now, all that stuff about your habitation and your property, that has been removed. It has been stricken from the record. It is only in defense of a person, and yes, that includes in your habitation, in your dwelling, aka a repeal of the castle doctrine. So it's not enough for somebody to break into your home and that is a substitute for the requisite intent for deadly force. They have to physically threaten somebody or offer violence to any person therein. Now, the next one used to read, when committed in the lawful defense of such person or of a spouse, parent, child, master, mistress, servant, and there is a reasonable ground to apprehend a design, and this is where it's crossed out, to commit a felony or do some great bodily injury and imminent danger of such design being accomplished, but such person or the person whose behalf the defense was made, if he or she was the assailant or engaged in mutual combat, must really and in a good faith way have endeavored to decline any further struggle before the homicide was committed. So this right here is the provision that they're talking about, how they need to add it into the law in order to prevent people from starting an altercation or starting a fight and making sure they have to leave that altercation or leave the fight. Well, guess what? In this particular instance, you just got rid of that whole section. The exact section that you said wasn't in the bill was in the bill, and you removed it, and you ended up replacing it with, again, a much more loose standard. Now, they also just wiped clean section 4, which says, when necessarily committed in attempting by lawful ways and means to apprehend any person for any felony committed, or in lawfully suppressing any riot or in lawfully keeping and preserving the peace. So in this particular case, if you see a dangerous violent felon and you end up having to capture this person because they're in the act of committing said felony, let's say they're assaulting a minor in a not so pleasant way, if you kill that person, that used to be a justified homicide, because again, this is a dangerous individual in the act. You are lawfully trying to restrain him for law enforcement, but guess what? In this particular circumstance, that's completely wiped from the board. That is not not protected activity, you are not allowed to do that. The citizen's arrest statute is gone.
Assemblymember Rick Chavez the Burr says they are making changes to make sure their intention is clear.
This is meant to make sure that the public feels safe and is safe in public places.
Now, they also add everything in Section B. That's why it's in blue text, and I apologize for all the different reading of this particular bill, but the fact of the matter is, it is very important for you guys to understand what's actually in this bill and how it not only repeals the castle doctrine, but it actually restricts in a multitude of ways a bunch of different various self-defense that have been in California state law for decades. And again, I will add that the Bruin decision does nothing at all whatsoever in order to make these loopholes or anything of the sort. Section B, homicide is not justifiable when committed by a person in all of the following cases. Number 1, when a person was outside their residence and knew that using force likely to cause death or great bodily injury could have been avoided with complete safety by retreating. Number 2, when a person used more force than was reasonably necessary to defend against the danger. Number 3, when a person was the assailant engaged in mutual combat or knowingly engaged in conduct reasonably likely to provoke a person to commit a felony or do some great bodily injury, except if either of the following circumstances apply. A, the person reasonably believed that they were in imminent danger of death or great bodily injury and had exhausted every reasonable means to escape such danger, other than the use of force likely to cause death or bodily injury. B, in good faith, the person withdrew from the encounter with the other assailant or assailants and indicated clearly to the other assailant or assailants that the person desired to withdraw and terminated the use of any force, but the other assailant or assailants continued to resume the force. Now, to be clear, Section 3, Parts A and Part B is what the state representative was referring to, and if you're going to clarify the language like this, even though it kind of already existed in the previous statute, I would be totally fine with this. But what this effectively does, based on all the different things, is that it ends up creating a duty to retreat within your own home, which again is very unusual because all 50 states have some version of the castle doctrine, which nerfs your duty to retreat within your own home. And in addition to that, it says that you cannot use deadly force against a bunch of different violent felonies that are committed against you, because those felonies may or may not rise to the level where they are considered by a left-wing prosecutor who's ideologically opposed to your self-defense rights enough to cause great risk or serious bodily harm to you or imminent risk of death. This is why we have these laws written so plainly and so much in simple English in a bunch of different states. This is why we say if they're committing a felony, rather than having a prosecutor try to adjudicate which felony was technically over this threshold or which one wasn't, because what ends up happening is defenders in states that don't have these protections end up facing lengthy court battles, and even if they win, they can go financially bankrupt fighting against these cases.
But critics like Craig DeLuce, Director of Communications for the California Republican Assembly, believe the bill could create confusion around when self-defense is justified.
My first reaction was, clearly this is offered by someone who doesn't understand use of force law, doesn't understand use of force situations.
DeLuce worries the bill could have an unintended consequence.
And what this does, it puts them in a situation where they could potentially hesitate and it could cost them or someone they love their lives.
So here you have somebody that is opposed to the bill, and he said it was written by somebody who does not understand self-defense laws, self-defense protections, and how they have to be worded in the state legislature, and he believes that this could cause people to second-guess themselves, and ultimately that will end up costing them their lives. Now, granted, I do think certain people might hesitate if they're aware of the law and they're afraid of the consequences of the law in the moment, but those cases are few and far between. The fact of the matter is, when you're in a self-defense situation and you have the capacity to defend yourself, instincts kind of take over and you normally act. But what this does do is open that person up to different various vulnerabilities from prosecution, and what you could end up with is a lawful self-defender in prison for a lengthy period of time, or at least being dragged through a lengthy court process.
Defense attorney Mike Wise, who has handled homicide cases for decades, believes the bill could complicate decision-making process for jurors.
Having tried a lot of homicide cases over the last 30 years, this is the kind of legislation that might sound good in a classroom, but it's not going to help jurors making critical decisions on a case like this, on a murder case.
So here you have an alleged defense attorney that honestly looks like an action hero or villain. I think he closely resembles the guy who played Cable in the Deadpool movie, or possibly Crossbones from the MCU. And he's 100% right about what he's saying here, that the original law didn't need to be changed. Maybe you could argue for that one clarification, the section 3A and B, but other than that, striking all this different stuff, vaguing up the language, making jury instructions more complicated, making people more vulnerable to prosecution is absolutely terrible. By the way, I will also point out for everybody out there in the audience who just assumes that a left-wing state has bad self-defense laws, that California's was actually pretty solid. It was actually pretty good. It was pretty respectable, and it might be better than the law that currently exists in your particular state, even if your state is a red state, because it turns out this didn't used to be such a partisan issue. A lot of red states had terrible self-defense laws, and they have been passing laws in order to improve them over time. But the fact of the matter is, this one was solid. It could have been left alone. The Bruin decision did not touch it. However, of course, they're trying to mess with it because they want to take away your rights. They are ideologically opposed to you defending yourself. But you know what? Those are just my thoughts. So like I said, I'm going to link the full bill in the description of this video. But I want to know what you guys think down in the comments below. If you like the video, show them by leaving a like, subscribe for more content, follow me on the social medias, support me via the support links in the description of this video. This has been me talking about California nerfing self-defense rights. Till next time.